also sanctioning increments on acquiring higher qualification, but no date has been mentioned. All that is clear in your lordship's judgment. There's no question of now saying that we will deviate from your lordship's judgment. And your lordship will see this.
State of Chhattisgarh, the GO issued by the state indicates that the committee is considering the mode of payment of the concurrent charges allowance, correct? The concurrent charges allowance. The state has issued a GO sanctioning the increments on acquiring higher education qualification, but no date has been mentioned for effecting compliance.
And out of 20, only 11 have been sanctioned.
And full stop. Out of 20 allowances, only 11 allowances have been sanctioned. Full stop. The state, the conduct of the state of Chhattisgarh is plainly unacceptable. Full stop. Despite 7 opportunities, 7 is there also, no?
Everywhere.
Despite 7 opportunities, the judgments of this court have not been complied with. We direct the personal presence of the Chief Secretary and the Finance Secretary of the state of Chhattisgarh before this court on 20 August 2024. 20 August bola tha na?
23rd minutes.
23 August 2024, together with affidavits of compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. All right, that's Chhattisgarh. Then full compliance by the 23rd. Yes, and the Chief Secretary and Finance Secretary have to be personally present in this court on that day. Now we're not going to say that if you comply with, then you need not be present, because then they'll not comply with. Only if we now direct presence that they will comply with. We now know how to extract compliance with the order. Yes. We're not going to send them to jail if they comply, but they have to be present here and tell us that they have complied. Nothing doing now. Yes. Which is the next?
Delhi, Madras, page 12. No allowances, no arrears of allowances have been paid.
Delhi?
No allowances, no arrears of allowances. Last 2 column.
The NCTD, the government of NCTD has not complied with the orders passed by this court. Full stop. No case for extension has been made out. Full stop. We therefore direct full compliance with the orders of this court by 14 August, by 20 August 2023. The Chief Secretary and the Finance Secretary of GNCTD shall remain personally present before this court on 23 August 2023, together with affidavits of compliance for the purpose of reporting compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. Then,
Assam, no compliance. They have moved an IA for extension saying citing floods because there was no floods in the year of.
Filed an affidavit, Lordship. Lordship, we have issued the notification. So far as 14 heads are concerned, Lordship, we have issued the notification, the report, because it came later, Lordship. That was the only thing, Lordship. The time, Lordship, that is being taken, Lordship, is we are really, Lordship, now facing disaster.
The council appearing on behalf of the state of Assam
situation
states that a notification has now been issued for the payment of 14 allowances.
14 allowances.
Full stop.
Not 7, Lordship, 6. Lordship said 7.
There has to be full compliance with the orders of this court. Full stop. This court is not inclined to grant any further extension of time or exemption to the state. Full stop. The Chief Secretary and the Finance Secretary of the state of Assam shall remain personally present before this court on 23. So, upar you likha tha na 20th August and 23 August. Same order.
Lordship, our situation is a bit critical, Lordship, is because of disaster situation.
Yes,
Very good.
With your
May I just give a lot of indulgence?
Everybody else, please circulate emails, because once we breach the norm, then I cannot breach it only for seniors, and I have to do that for everybody else. It completely destroys the system which I have put in place. Everyone who has a request, please send me an email. I'll look at it by the afternoon today.
No, this is not a listing request.
Mine is not a listing.
Anybody who does not have a listing request, some correction in an order, something is free to mention.
There's a matter coming tomorrow. We're asking the review today to be put with that tomorrow. That's a request.
That also has to go on an email. That's a listing.
I'll put it in the email. Put it in the email.
Listing, if it's on listing, please don't mention. Please put it in an email. I'll look at it in the afternoon today. I promise you I'll do that. It's the same thing. When was the impugned order passed?
Now my difficulty is building may be demolished. Compliance would have to be
By 19th, right? So we'll list it tomorrow.
Your Lordship, I'm just seeking
List it tomorrow.
permission to
No,
circulate.
but you could have also said it in an email. Sorry. Circulate a rejoinder.
Circulate a letter in tomorrow's matter listed at item 26. And for the respondent, we just need
Too
some
late
time to
now.
come.
We'll see tomorrow, yes.
Because I'm mentioning a matter where I've already sent emails, Malaj. Malaj, I've also sent
It will be
emails
dealt
this
with.
morning.
It will be dealt with.
This
Puneet,
morning
just
also,
make
Malaj,
sure.
I'll meet you.
Mr. Shoaib,
Just a query, would your Lordship be taking the part third income tax matter or?
Just
Would you-
wait. I've just told the court master, we'll tell you in a minute, yes.
My lord, sorry, I just one request. There's an order that your lordships had passed last week, my lord. It's an arbitration petition. Your lordship perhaps will recall, notes, I had made a submission that the pendency or the reference to arbitration will not impact any criminal proceedings that we might initiate. Because our recollection is, my lordships had dictated that in court, my lord, but it's perhaps not reflected in paragraph 3, my lord.
No,
Your Lordship,
we also said in the course of the discussion
Please, my lord.
that an arbitration will never affect a criminal prosecution.
But I made that submission, I think,
All right.
Your
We
lordship
don't have to
had
put
made that
something, we
also-
don't have to put something, clarify something which is obvious.
very good.
So before we begin, what we're proposing to do is that we have the income tax part third group. NEET is above that today. We'll at least open the NEET matter and then we'll see what to do with the part third group. We'll hopefully start with the part third group, but it might just have to wait until we open the NEET matter because there's some urgency in the NEET matter. Young students all over the country are waiting for the outcome of this matter. So, but we are not going to lose session of the income tax matter because we are now also mentally we are in the matter.
But may I suggest, since we have circulated something yesterday, it can be kept tomorrow also.
Let's at least open the NEET matter today because, you know,
We will waiver.
let's see the matter.
The others can be discharged, etc. Many are procedural matters, item 4, etc.
So what we are doing is,
Procedure.
field number 1, for instance, is about bifurcating. We'll take up item 1. So it's bifurcating matters, etc. That will pass procedural direction.
Four is for compliance like that. When your Lordship comes.
Right, we'll just, yes.
I'll go into.
No, no, item 1 is not bifurcating. Item 1 is a batch of cases on fringe benefit tax.
Yes, the fringe
That will come on
benefit
some
tax.
other day. Yes. The bifurcation is the gaming matter, I think, if I'm not mistaken.
Why is that listed for directions? Because item 1 is only listed.
No, there are two appeals.
All right,
and there
then
are other
item
transfer
1,
petitions.
right, the court master says that, you know, we have to pass the usual procedural direction for appointing nodal counsel so that they prepare one common compilation. So tell us who will be the nodal counsel.
That's right.
No, Mr. I'll give my AOR's name to your Lordship's bench, my lord. And one from the department. So 2 of us can be there.
Is
give
there
me by
a
lunchtime.
compilation for the department? Is there a compilation for the?
Only for the petition.
So now tell us for the petitioners, who will be the nodal counsel?
Malaj, I can volunteer.
Mr. Kunal Kishore can.
Ma'am, since you've already prepared.
Anisha Karya, I've already our compilation.
And for the department, Mr. Venkatraman, are you appearing in the one? You are appearing. Who will be the nodal counsel there?
Mr. Divakar.
Mr. Divakar. So Ms. Manisha Karya and Mr. Divakar will be nodal counsel. usual orders, and prepare one common compilation duly indexed with written submissions in terms of our last circular, and file it. By what date will you file it? Mr. Datar, by what date will you file the compilation?
Your lordship is posting it in August, my lord, or July?
We'll post it in August, so we'll give you enough time to file the compilation. You can file the compilation including written submissions by the 31st of July, and we'll place it in August. All right, so that seal number 1 is over. That way, we have just one compilation, otherwise it becomes impossible to.
Item 2, my lord, the canon matter, my lord, they have put a direction now. It has to be, bench has to be constituted, the lot of batch of matter there.
So here also, can we have one compilation, please?
Yes,
we can do a compilation.
Right. So who will be the nodal council?
I will.
Charanya will be the.
From our side, V. Chandrasekhar Bharti will be the
So.
panel council.
Charanya Lakshmi Kumar and Mr. V. Chandrasekhar Bharti. And can you prepare the submissions and compilation by 31st of July?
No, definitely.
Definitely.
Then we'll keep it in the first week of August and we'll take it up. Because a lot of matters across India are dependent on this.
Pending.
Thousands.
Thing is, Majmur is 3 member bench. Because this matter, the canon matter was passed by 3 judges.
Right.
Therefore, it has to be.
It has to be 3 judges. It'll be before this regular bench.
Yes,
It'll be before me and my 2 colleagues. So we are seized of the matter.
As it pleases.
Item 3 is the Google matter.
My lord, I appear for Google. Your lordship recalls your lordship.
What we'll have to do is, are the compilations ready in Google?
Everything is done. My lord, give dates in September.
Today, Mr. Sarkar, only because we have the NEET matter and, literally lakhs of
my lord,
all over the country are waiting for the outcome of this matter.
No, in September, my lord. Give dates in September.
Probably in the first week of September, so that we can
My
conclude.
lord, a little later, I have the Indus Valley dispute before the neutral expert in September.
Second week of September, my record.
After 15th, my lord. After 15th, any day.
Submissions have not been received, the court master says, so you'll have to email them.
That will make sure, my lord, are sorted
All
out.
right, why don't you give us on the side of Mr. Salve one nodal council?
Lordships,
Yes.
we have filed it. We filed it on the 3rd of October. We'll file it again. We'll send an email again. It's been filed.
All right, who's the nodal council on your side?
Mr. Chandelier is the nodal council.
Mr. Chandelier, and what about Mr. Venkatraman, your side?
Already said in
We've already appointed nodal council. All right, then make sure that is filed by the 31st of July. All right.
Yes.
gaming matter.
This again, my lord, is the gaming matter.
Are these absolutely ready for
Union Madras has filed its counter, where lordships are directed
Hello?
violations to be filed, appointed nodal council, that is not.
We can do it one of weeks.
Violations
So we set down 31st of July for completing the filing of the compilation.
Maybe 15th August may be better, Malad, but I'll leave it to.
Anti-profiting batch we can exclude, but amongst gaming, no segregation, my lord. Everything has to be heard here.
Agreed. My friend is right, my lord.
One second.
15th August may be better.
This exercise has been done in the registry.
Yes, yes.
The gaming matters we've got separately listed and the anti-profiteering
Yes.
matters are separately.
Correct.
So
Lordship.
they have to be segregated. Now, what we will do is that the learned council can, this has been done by
The
Charanya.
list is made. Charanya has
Have
made.
you looked at it?
Just check it up, Lord. Just give it to me now.
All right, Ms. Charanya Lakshmi Kumaran, learned counsel appearing on behalf of the petitioners, some of the petitioners, has prepared a tabulated statement segregating into single invert commas, gaming into invert commas, matters from into single inverted commas, anti-profiteering matters. Full stop. The statement is reproduced below. Copy kar lijiye. Mr. N. Venkatraman, learned ASG, states that he will have this duly verified within the course of within a week. And intimate the registry in regard to whether he agrees on whether the statement reflects the correctness of the statement. Full stop. This may be communicated to the court master no later than by date de dijiye on the email ID. The compilations are ready.
The counter was received by us in the writ petitions on Monday evening. So we need some time to file the rejoinder.
If a rejoinder has to be filed, that may be filed on or before 31 July 2024.
We can-
Lordship, some of the transferred matters, the councils indicated that they would also like to make written submissions when we checked with them. So they were waiting for direction.
All right, if any further written submissions are to be filed, including the transferred cases, they may be filed with the nodal council, who will add them to the common compilation. So the written submission shall not exceed 5 pages each. Because
would your lordship settle down on
now the others
31st
are
for
just
directions?
add-on.
Would your lordship have it on 31st for directions, Manoj?
We'll have it on the 31st of July for directions.
Right.
For the directions on the 31st, which is a Wednesday.
Lordship,
All right.
Directions.
Why not still segregate it?
We are segregating gaming and the two sets of
Anti-profiteering.
will be taken
We have
separately.
no difficulty in segregating gaming and anti-profiteering. Now, any
That's all.
segregation within gaming is not acceptable.
That's
No,
all.
no.
So we are not asking for it
No,
now.
somebody last time said game of skill should be segregated.
Mr. Venkataraman, now you're giving them ideas.
Yes, correct.
No games.
Nobody is ready for normal.
All right, now, so that covers 4, 19 and 20.
Anti-profiteering some date.
So 31st of July, we'll keep it for directions.
Yes,
Just to ensure that everything is complete, then we list it immediately and hear this.
great.
Oblige, Manoj, oblige.
Lordship.
Matter, because this is for the gaming matter, now the counter, etc. we have prepared. For anti-profiteering matters, there are no directions in terms of
The circular.
permission to
So for
file.
the anti-profiteering matters, we'll issue similar procedural directions, same nodal council,
Can be then.
same nodal council, same. And by 31st July, that process must be completed.
We can do
All
that.
right?
Obligation.
That is neat.
Please bill us.
Mr. Agde, we'll now stand back the income tax matters. We are not adjourning it for the day, but in view of the importance of the NEET matters, we'll take up the NEET matters, because but all the other learned council may step aside and you can have a little time off, but we'll take up the income tax matter because we're not taking up any other heavy matter until we take up that. So NEET only because of the social ramification, we thought we'll give priority to the NEET matter. Right now,
They're all mixed up. 5, 7, 9 and all that.
now who's going to open the arguments in the NEET matters for the petitioners?
My lord, my item 5 is slightly on a different footing. I am showing not merely the leakage of the examinations, but I am showing the.
Because mine is the first matter wherein the.
Mr. Dwivedi, where are you appearing in this matter? This pension matter. I think you're safe today because, if after this, we are going to take up the parted tax matter, which will take the rest of the day. So, but the judge's pension matter is again important and we will take it up probably next week. We'll list it and take it up. Just a little adjustment of the board, that's all.
So far as item 7, if not, I can. The writ petition under Article 226 of this candidate is pending before Honorable High Court of Delhi. He has filed writ petition under 32 before this Honorable Court also, saying that I'll withdraw that. This is the third time consecutively where he is alleging that my OMR has been replaced, which is factually.
All right.
That
That we will see what to do there, because that's not about the systemic issue, but about his own OMR sheet. There we may be, who's appearing, which one is that serial number?
Item 5. My lord, in 514.
So 5, why don't you do this? Go to the High Court, whether your OMR sheet has been replaced or not, there is not a systemic issue.
High Court has already passed the judgments. High Court has refused to examine this issue. My lord had delegated.
So why have you filed a writ petition? You have to file an SLP then.
No, my lord, in 2020, I went before Honorable High Court on the directions of this Honorable Court.
But now High Court is held against you.
In 2021.
21 hoga, 20 hoga, 19 hoga, 23 hoga.
My lord, since then.
But now tell us, what remedy do you have against that judgment of the High Court?
Against that, even if I come in SLP, my lord cannot grant me an admission. My lord, I am saying I reappear in the examination in the.
Fair enough. We'll entertain your writ.
Yes.
On one condition, that now then we will treat the order of the High Court as attained finality.
Yes.
So we will then hear your writ on the footing that the order of the High Court has attained finality. So you're taking a chance.
My lord, High Court refused to examine the issues. That's the final.
All right, we'll see. We'll see when the matter is called in.
My lord, may I?
Mr. Nagamutu, we are seized of the matter. We know how important it is. It's about our own retired judges. But We have the NEET matter today, so we'll give priority to the NEET matter today. We just indicated to Mr. Dwivedi, we'll try and accommodate it sometime next week, so we'll take it up immediately. We'll just give me a little time, so I'll just in the evening discuss the board position with the court master, and then we'll fix it because we have to take it up.
My lord, I'm here for item number 6. I have the same prayer that my OMR sheet was replaced and the.
All right, let the matter open up now. If everybody just keeps on giving your individual fact, who's going to open the hearing?
Yes,
Open the argument?
mine is the first matter, my lord, where they have filed their responses.
So we'll hear Mr. Huda first.
Yes, my lord, I'll supplement whatever he is.
All right, and then we'll hear the solicitor.
But your lordships had an occasion to go through the second status report.
Yes,
CBA.
we have seen the second
Now
stage.
there is something is crystal.
We have seen the second stage.
Yesterday it was.
Yes, I saw it in the morning today. After we
Please.
both my learned brothers have seen the second status report. Oh, ऐसा करो।
May it please your lordship. No. So yours?
Just one suggestion.
Okay.
All my.
Okay.
Okay, first.
In item 5, may I please request that the first prayer is, my lord, that
You're not arguing it. You have somebody before you who is to argue his matter.
they are in item 7 and item 5, I am making a request.
But which is the lead prayer? Which is the lead matter? Are you prepared to argue the whole matter on the leak, etc.?
No, I'm on the, not on the legal aspect, my lord.
Then
I'm
why are you
saying-
why are you interrupting the flow of the proceedings? You know, allow somebody who is arguing the main matter to take charge, right? We'll hear you. We'll hear you at the end. No problem.
Since not replied. May it please your lordship. Lord, 2-3 things at the outset, Lord. As per my lord's direction, CBI was supposed to file their status report. Filing, we understood it will be filed and it will be supplied to us. And that was the direction.
Problem is this.
Pardon?
The only problem is this today. I
Please.
mean, I'm all for transparency. In fact, this is not a sealed cover procedure. Let me be very clear. But today an investigation is going on.
Correct. I
Right?
quite follow that.
If what CBI has told us in the course of the investigation is revealed, probably the investigation will get scuttled because people will become wise on what are the leads which have emerged in the course of the investigation. So that's the only thing.
I bow down, Lord, straight away. My only, you see, the intervention in between will cause a problem.
So what we would like you to do, Mr. Huda, is
Please, Lord.
you have to, you know, redaction is not possible in these kind. If it's redacted, then it'll have nothing of it'll have nothing of substance. You will have to show us prima facie on the basis of your submissions that the leak is so systemic and has affected the entire examination process across the country that we must cancel the examination and direct a fresh examination to be held.
Yes.
That is the area where we want to hear you.
Lord,
And then we'll hear the learned solicitor in response to that.
I will assess this honorable court
Then,
of that
what-
area.
just one second. Second, we have some ideas also on what we are going to pose to the solicitor thereafter.
Please, Lord.
We would like you to assist us on assuming, if we accept your wider submission that you must have a fresh NEET examination, then that's what you exactly want. Suppose in the alternative, after hearing you both, we are not with you. Then we would like you to also assist the court on which are the further lines of investigation, what are the lines of investigation which must be carried out? In the sense that which are the specific issues which must be investigated. So we would like your assistance on both. The other is an alternate argument.
Yes, but that alternative argument has also come in my supplementary note, which I've circulated yesterday.
Okay, we'll
in the
take that.
same matter, I have suggested that this is the line of investigation should be conducted to unearth this entire controversy.
All right, then we'll look at that. Later on, we'll read it with you.
At the outset, my lord, I was flagging my handicap in assist. My lord, I'm assisting. I'm not saying that. But the handicap I have in assisting this honorable court in this leak matter, one, they have not declared the entire result. They have declared the result of 100 people. And my assistance is information gathered from here and there. UPSC, my lord, in IAS exam, they declare the result of entire people. At least they should have declared the result of this 1 lakh people who get admission, first 50,000 in the medical colleges.
Just one second.
The two handicaps, my lord, may kindly notice, I will have in the course of my assistance to this honorable court.
50,000. How many seats in the government medical colleges?
56,000. And Lord, everybody clamor for these first 56,000. Even the people below 56,000 may be willing to go for a re-examination.
And how many in the private medical colleges?
52,000. 56 and 52. That is 1,08,000. Now, my lord, if re-exam happens, literally it is, if all of them do not want re-examination, the total number is 1,08,000 people, not 23 lakh people. The remaining 22 lakh people
have not got admission at all.
Have not got admission. So they are willing.
Except for the fact that if some people have wrongly got into the 1,08,000 category,
that's right.
Then somebody below the 1,08,000 can legitimately get into that 1,08,000.
Correct. That's right. So, but in fact, the balance is this 1 lakh. If all of them 1 lakh don't want re-examination, this 1 lakh on one side and 22 lakh on the other side who would like to take a chance in view of the this examination is marred by controversy. All 22 lakh would like to have a second chance.
That argument,
yes,
Mr. Huda, there's a problem. Forget the question of leak in this matter. Merely because, say, out of 22 lakh, 1,08,000 only have got admission or would get admission. And therefore, you are left with, say, about 20 lakhs, 22 lakh students who would want to take a chance. We cannot order a re-examination merely because they want to take a chance.
That's right. But I just wanted
re-examination has to be on a concrete footing, that the sanctity of the entire examination has been broken.
I bow down. I just wanted to dispel an impression that the stake in the re-examination is of lakhs of people. No, the stake is of 1,08,000 people. I will have to set up, demonstrate conclusively that we cannot segregate tainted from the untainted. In Tanvi Sabharwal case and the judgment authored by Malo, clearly says in Tanvi Sabharwal's case, the finding was we have identified 44 candidates out of 6 lakhs. The remaining we are not able to identify. So we cannot permit even 10 people.
Mr. Huda, I think, you need not labor that point because you're absolutely right on that.
I'm so grateful.
That if you can, conceptually, that if you can establish that it is not possible to segregate the tainted from the untainted, then the whole examination has to go. Because those basic, you can of course show those authorities briefly to us at a certain point.
Please.
But when we have looked at the facts, but before we go into the authorities, we want you to address the core of the facts before us.
I will try to first summarize my case and then elaborate.
All right.
So that has an idea what I am saying.
So you can summarize now. My brother Justice Pardiwala would like to know, out of 1,08,000, totally how many petitioners are before the court?
Lord, it is NTA can say.
NTA, 38 petitions.
Yes.
Now, you're for NTA, no?
Transfer petitions filed by the NTA, my lord.
So 38 petitions includes the 6 transfer petitions or transfer
petitions before this honorable court would include the 6 transfer petitions
All
filed
right.
by the NTA. So
But
32 petitioners, 32 petitions.
Our question is little. How many?
So,
8,000.
I represent 10. I'm from.
How many are asking for?
Supported by 43 more from.
I do not know how many, at least 100, the candidate must
Alright.
have called us individually, but who have not
I
participated.
think they have a figure.
108.
108. Mr. Kaushik, if you can just ask somebody, any of your team from the NTA, to just do this physical exercise of telling us even at lunch or after lunch, how many total students are involved in the matters before the, not involved, but how many students have moved the court in this batch of cases?
Lords, with utmost respect, my lords, that way.
Approximately, 108 are seeking reconduct of the
The
examination.
council,
50. Yes.
108 who are seeking re-exam are amongst 108,000.
No.
Yes. Yes.
No, they'll be outside 108,000.
We are outside 108.
They can't be. They can't.
Because 108,000 would get, they have succeeded.
They are not seek re-examination at all.
I represent
So all those who have not been able to
Yes,
clear.
yes.
They are not.
Some people within 108 are also before your lordships because they say
They will not get into government medical.
They will
not
not
get into government.
they will get into it.
My lord, in my picture,
seeking re-examination.
in my picture 700. In my lab picture, my lab, there are 5 candidates. One of them.
Now in charge, unless we ask a question to some other council, the others may not interrupt because otherwise, our line of thinking is also affected. And he's deflected also. He has his thought process in some matter, yes.
Students out of total.
But they are not in mission.
I'm on your side, ma'am.
Also, Brother Manoj Mishra had a point. What is the minimum mark which has been received by the petitioners before the court? We just want, you need not give us an offhand answer, just do it at lunch and tell us.
My lord, can I one thing, my lord? In 5 petitioner in my petition, my lord. One is having, my lord, 700. Another is having 600.
How will we be able to, just wait for a minute. Let's have the conceptual basis of the matter. We can't go in individual facts like this. Let's have the concept very clear before us and then we can see where the balance lies. Yes, Mr. Ola. We'll hear you. We're not going to run away. We are here to hear you and do justice to the matter.
Qualifying marks are 164.
Done this exercise. There are 131 students who are not falling within 108,000 and they are playing for retest. 131
students.
130. And there are petitioners and there are 254 who are falling within 108,000. They are opposing them. Not that statistics can assist your lordship either way, but factually this is the position.
So 131 students beyond 108,000 who want a retest and
254, they are in the form of IAs for implement.
Who are opposing?
For opposing the retest.
They
fall within 108,000.
The figures may not always be right, my lords, because I represent somebody who falls within.
Yes, that's true.
And whose rank is about 2009. But, my lords, we'll work out the figures in common with Mr. Kaushik.
Now tell us also what is the cutoff rank for the 56,000 and for the 108,000.
May just one clarification conceptually. Anybody who is above the 50th percentile qualifies in the sense that if somebody above them also does not go into medicine, goes into IIT, for instance, there will be a figure. So passing is 164. Passing is 164, but admission is a dynamic process, may stop at 1 lakh, may stop at 1,50,000. And depending on the particular quota or reservation or whatever is available. 164 is the cutoff mark. 164 means that you are above the 50th percentile. So about half the people have a qualification to be allotted a seat, but not everybody will be allotted a seat. So it's a dynamic process. There is 108,000 seats available. Some of them may not opt for medicine, some may go into IIT, this, that, and the other. The figure will come down. And also depending on whether you have a reserved category or something. So it is not, so it is dynamic, but roughly saying, I think the last figures will stop at 2.5 lakhs, rank wise. That's
Well, let's hear Mr. Hudana. Yes, Mr. Hudana.
So, my lord, I'm
You
starting.
can summarize your case, you say.
Yes, yes, my lord. I'll just summarize, but it will, give me a space, please. थोड़ा सा पीछे हो। Lord, I'm starting with a handicap. I do not have the result. Because of that, I cannot have the data analytics, which the state has placed, NTA has placed on record, giving the bell curve. And Lord, one of the director of IIT Madras is a member of the governing body of NTA. They have run the data analytics process, taking the entire number of 23,33,000 candidates who sat in the examination. If data analytics is to be run to 23,33,000 people, at what stage 10,000 or 20,000 people have sneaked into it? This data analytics running into half a page, which every dot means thousands of people. You cannot detect any abnormality when you draw a bell curve, which is based on 23,33,000. The correct procedure, if at all they were doing it, the correct procedure was to apply this process to 108,000 people. The first 1 lakh people in 2021, 22, 23, and 24. Probably the curve would have been able to catch 1,000, 2,000 people going up and down. Now even 1% is up, is into thousands of candidates. This honorable court has not tolerated, even if it comes to a conclusion that 1,000 people have entered into the system of this 1 lakh, which we are not able to detect. This examination cannot be sustained.
Well, that's one aspect about what IIT Madras has done. Now, what about, how do you develop, now you can develop the basic case that you have.
I'm demonstrating that IIT Madras can't be relied upon.
Because they have taken the entire body of 21.33 lakhs.
That's right.
And according to you, that data analytics should have been done on the restricted figure of 1,08,000 and compare that with 2021, 22, and 23.
So great. And Lord, the governing body member is the of NTA is the director IIT Madras. There is a conflict of interest. Lord.
No, but therefore, you take it, I mean, what is at the highest, what does that lead to? Your argument is that the data analytics has been done by NTA itself.
Correct. That's right.
It can't be higher than that.
And apply.
That's because because the director of IIT Madras is also on the governing body of NTA.
That's right.
Actually, he's not.
He's not, they
He's
say.
present in
But
the court on my request.
Right.
He says he's not on the board of directors of NTA.
Oh, I see.
He was an outsider whose without expertise.
But anybody from IIT Madras who is on the governing body of NTA?
He was. Somebody else was.
Was means in the past.
In past.
Today, IIT Madras has nobody from IIT Madras in NTA.
When was that password when he exited?
But the director who has prepared this report.
Mr. Solicitor, just sit for a second and ask them what the position is so that you can have a seat.
Were you a member of NTA? This is not the way it is done. Please don't do this.
I have not attended any board, nor do I.
Member. He's not a member. Any other person who is a member. When? Subject to further verification. But the IIT, whichever IIT organizes JEE examination, IIT JEE for selection in, the chairman of that examination committee is ex officio member in NET, NT. But the office, the director who has prepared this report is not the member. But some Mr. Gopal.
Now, the IIT JEE for 2024 was held by IIT Madras or who else?
IIT Madras. He is the chairman of that IIT JEE examination committee, but he deputed somebody to attend meetings of NTA.
Oh, I see.
Ex officio is there to use his expertise.
So I'll just take it down. IIT JEE for 2024
was conducted by IIT Madras.
Yes.
And the chairman of IIT who conducts IIT JEE, ex officio is a member of NTA.
And what role does NTA have in regard to the IIT JEE?
Nothing.
There's no.
He is no,
just ask the director.
NTA conducts JEE.
So the actual NTA, the actual IIT JEE mains are conducted by NTA.
Yes.
Oh, I see. So IIT Madras would only set the papers, or what happens?
No, they would conduct the examination. JEE advanced they conduct, JEE mains is conducted by NTA.
Mains is conducted by
NTA.
NTA. That's like the preliminary exam. The mains.
Advance.
Advance is like, no, advance is only IIT.
May final.
This is only for IIT. Whosoever is intended to get admission in IIT, they opt for the advanced. Otherwise, all other
They are only the admissions are on the basis of IIT JEE mains.
The mains.
And IIT JEE advanced. NTA doesn't conduct that. So IIT JEE advanced is conducted by whom?
NTA.
No.
This is conducted by IITs.
IITs or one IIT?
One IIT. It is conducted by IITs. One become the organizing IIT. This year it was IIT Madras.
Okay, so like the CLAT.
Yes.
So this year, the IIT JEE advanced, the organizer was IIT Madras.
Correct. Okay. And my lord, he has gone into city-wise as well as center-wise analysis.
Now, when you said that the chairperson of IIT JEE is the ex officio member of NTA,
Governing body.
of the government, is ex officio a member of the governing body?
Yes, and governing body has no correlation with the activities of the conduct of the exam.
So the IIT JEE, the chairperson. So this time, who was the chairperson?
I took this time chairperson. He was the chair.
He was the chairperson. He deputed one Mr. Gopal Krishnan to attend the meetings on his behalf.
No, but who was the chairperson? The director of IIT Madras was the chairperson?
Yes. For G. Because IIT Madras was the organizing body.
So IIT Madras was the organizing body both for the mains as well as advanced, or only for advanced?
Only advanced. Mains was conducted by NTA, by us.
Entirely. But IIT Madras's director was an ex officio member of the
governing body, Manoj, which is a kind of a
NTA.
making.
Of NTA. And is he an ex officio member only for this year or generally?
He would be, whichever IIT conducts the exam.
For that year, he becomes a member of the governing body. All right, I got it.
I must tell your lordships, my lord, that what is placed in the report is, my lord, for, say, a city-wise spread of top 100 rankers.
This time, the director IIT Madras would be ex officio member of the governing NTA, but he had deputed somebody else on his behalf to attend the meetings.
One Mr. Professor Gopal Krishnan. And I have city-wise and center-wise.
So that I'm explaining.
Deputed professor or doctor?
Gopal Krishnan. Professor Gopal Krishnan. But if my learned friend is going on the question of bias, that may not help here. I have sat with him, my lord, I have examined everything which he has done. Yeah, I can show it to your lordships, and Lord, it is city-wise, center-wise, and at the national level.
Yes,
Lord, just so that there is no.
That you can indicate when your turn comes. Notice. All right, now tell us.
Without showing the document, but that city-wise and center-wise, the first table is, my lord, the bell curve of 23,000 people. 23 lakh people. The second table is city-wise top ranker analysis, the top 100, how top 100s are spread over across the cities. Then there is a table which gives
Can we do this, Mr. Huda, to understand your submission? Can we just look at the report of IIT Madras?
Yes, I straight away
Let's
demonstrated.
go straight there because
Yes,
let us first understand what they have done.
Yes, that's great. Lord, may kindly see the reply filed by them on 10th of July.
Just one second. Serial number kaun sa hai bhai ye?
Union of India.
Additional affidavit dated 10th of July filed on behalf of respondent number 2, Lord.
NTA dated 10th of July?
Correct, Lord. That's right. Lord, this is respondent number 2. Annexure A, Lord. Page 12.
Page 950 तो है ही नहीं बोलता. It's analysis of the 17 candidates or no?
Lord, this annexure is data analytics of NEET UG 2024, annexure A.
Lord, it may be part of the petition filed by Shivangi Mishra. Item 7.1, so that was the first.
Yes.
Yes, it is in Shivangi Mishra's case, my Lord, because they didn't file it in my case.
Yes.
Yeah, we got it.
But copies are served on.
Yes,
That is
copies are.
report from IIT Madras, pages 12 to 18. Let's see that.
Yes, now, you see, and at page 12 is, there's an executive summary given on page 1, and then the charts. Executive summary indicates they have gone all the way to explain. If I can read it, the executive summary.
Yes.
Marks distribution follows the bell-shaped curve which is witnessed in any large-scale examination.
Just one second.
Executive summary, short summary. Marks distribution follows bell-shaped curve that is witnessed in any large-scale examination, indicating no abnormality. City-wise and center-wise analysis done for 2 years, 23-24, to find out if there are any abnormal indication. Analysis is carried out for the top 1.4 lakh ranks, given that the total number of seats across the country is around 1.1 lakh. This analysis is granular enough to indicate any abnormality had a large number of students gotten into high rank top 5% due to malpractice, or if students from a particular exam center or city were benefited. The analysis show that there is neither any indication of mass malpractice nor a localized set of candidates being benefited leading to abnormal scores. I would say this is beyond their brief, what they are stating here. D, there is an overall increase in the marks obtained by students E part. There is an overall increase in the marks obtained by students, specifically in the range of 550 to 720. This increase is seen across the cities and centers. This is attributed to 25% reduction in syllabus. That's not their case for them to say. In addition, the candidates obtaining such high marks are spread across multiple cities and multiple centers, indicating very less likelihood of malpractice. Lord, if I can take just one moment here. NTA, the Government of India, in their reply is